You're online, Evelyn.
Okay. It's so weird because it doesn't go back. Hi everyone, it's Evelyn Ackah. Thank you for joining me on the Ackah Law LinkedIn Live Wednesday morning. Many Canadians assume that because Canada and the United States are close neighbors, crossing the border should be simple. In many cases it can be, but entry is not automatic. Even though Canadian citizens generally do not need a visitor visa for short-term tourism or business visits to the United States, they still need to satisfy a U.S. Customs and Border Protection officer that they are admissible and that their purpose of travel is allowed. Today, I'm going to walk you through the most common refusal concerns that Canadians may face when entering the United States, including unclear business travel, work without authorization, criminal history, DUI concerns, cannabis or drug-related issues, previous refusals, overstays, and what to do if you're worried about being turned away. This is general information only, not legal advice, so please don't rely on it. Every situation depends on the facts, and you need to speak with a lawyer. So the first point we're going to talk about, a Canadian passport does not guarantee entry. The first thing you need to understand is that a Canadian passport allows you to travel to the US border by plane or by road, but it does not guarantee you will be admitted to the United States. A CBP officer may ask one or more of the following questions that you must answer honestly. Why are you going to the United States? How long are you staying in the United States? And where are you staying in the United States? Sometimes they'll ask you, who are you visiting? As well as, are you going for tourism, business, meetings, family reasons, study, or work reasons? And sometimes they'll ask you, who is paying you? And do you have enough money for your stay? Do you also have strong ties to Canada that will prove you will return to Canada after the term of your visit? The officer needs to be satisfied that your purpose of travel is genuine, temporary, and consistent with U.S. immigration rules. So the first message is simple. Being a Canadian citizen does not mean you have automatic entry to the United States. You still need to be deemed to be admissible, and you need to be truthful and be prepared. Even if you've entered the United States many, many times before, each entry is still a new inspection point. A previous smooth crossing does not guarantee that the next one will be the same. Next point, business travel versus working in the United States. One of the biggest issues we see is that Canadians will say, I'm just going to the United States for business. But under U.S. immigration law, not every business trip is treated the same. Generally, business visitor activities may include such things as attending business meetings, attending trade conventions or consultations such as a conference, consulting with business associates, negotiating contracts, doing sales activity, meeting clients or business partners, participating in short-term business activities. But a business visitor should not be entering the United States to perform employment or productive work for a U.S. company. That means Canadians can run into problems if they are going to the United States to perform hands-on work, or provide services to a U.S. client, or to fill a role for a U.S. company, or to work on site at a U.S. office, such as installing, repair, or performing technical work without proper authorization. That looks like work as opposed to business visitor activity. You have to be very careful. This is where wording really, really matters. If you say I'm going to work with my client, or I'm helping them complete a project, or I'll be on site for a few weeks, the officer may ask you more questions to try to determine if you are working illegally without a work permit, or if you're doing permitted business visitor activity, which you can enter the U.S. under a B1 business visitor activity. The key point is this: do not assume that business means you can do any kind of work in the United States. That's wrong. If the activity is more than just attending meetings, planning, negotiation, or sales, or consultation, you should get advice before you travel because it could affect your ability to get in successfully. Point number 3, authorization and TN concerns. For Canadians who do need to work in the United States, there may be several options depending on the role, employer, and long-term goal. For many Canadian professionals, the TN classification under the USMCA can be one of the most common options for entering the United States with a work permit to do legitimate work activity. But the TN is not automatic. To qualify, you generally need Canadian citizenship, a U.S. job offer or contract, a profession that is listed under the USMCA, the required education and credentials, and a role that matches the professional category. Clear supporting documents are required to prove that you qualify for the TN visa, and some people are refused because the job title does not match the TN category, and the duties are too vague, or the support letter is weak, or the officer believes the person is not truly coming for a temporary professional role. Other work options may include the L1 for intercompany transfers, the E1 or the E2 for treaty trade for investment, or even the H1B specialty occupations, or the O1 for extraordinary ability or other categories depending on your specific facts. The most important message is this: if you are going to the United States to work, do not wing it, ever. Prepare the correct category, make sure you have everything you need so you can take one shot at it to be successful. If you have any criminal history or DUI concerns, that is another fear that many Canadians have about crossing the border. Some travelers worry that any past criminal issue will automatically stop them from entering the United States. And this answer sometimes depends on the facts. In order to know more to give legal advice, we need to know what happened. The U.S. does not treat every offense the same. Certain criminal issues may create inadmissibility concerns, including crimes involving moral turpitude, controlled substances, drug trafficking, fraud, theft, assault, multiple convictions, or other serious matters. For them, DUI is a common question. A single DUI may not be treated the same way for the US as it is for Canadian entry. However, multiple DUI convictions or a DUI combined with other offenses such as causing bodily harm, etc., they may require a visa waiver before you can travel to the United States. The details truly matter. What was the offense? Was there a conviction? Was somebody killed or injured? Was the charge dismissed? Was there a plea? Was there probation? Has it been expunged? Were all fines and conditions completed? And was anyone harmed? Was there more than one offense? And was there any drug-related issue involved in the offense? If you have a criminal record, do not guess at the border. Know exactly what to expect and bring certified court records if needed, and get advice from a lawyer before traveling. It is always much better to understand the risk in advance than to be surprised during inspection and you miss your chance to go on vacation with your family or Disneyland, etc. Point number 5, cannabis and drug-related issues. Cannabis is another area where Canadians need to be very careful. Cannabis may be legal in Canada and in some states in the US, but not across the whole United States. It is not legal under federal law in the United States, and this can create problems at the border. Canadians may face questions if they travel with cannabis, if they have past drug-related charges, if they have worked in the cannabis industry or they continue to work in the cannabis industry, or they invest in cannabis businesses, or they admit to drug use in any way that raises inadmissibility concerns. The key message is simple: do not travel with cannabis. Do not assume Canadian legalization protects you at the border. Also, do not misrepresent anything to a border officer. Misrepresentation can create as much of a problem as other immigration issues could create. Honesty is important, but so is preparation. Point number 6, previous refusals, overstays, or immigration issues. Another concern is past immigration history that will affect your ability to get into the United States. This may include a previous refusal at the US border, a canceled visa, a prior overstay in the United States, working without authorization, studying without authorization, a previous removal or expedited removal, or misrepresentation at the port of entry. Inconsistent answers in the past applications or interviews may also affect your ability to enter the United States. These issues can have serious consequences. One of the biggest mistakes travelers make is trying to hide a previous problem. If you were refused before, overstayed, or worked without authorization, or had a visa canceled, the solution is not to hope the officer does not notice. The solution is to understand what happened, gather the right documents, and get advice before trying to enter the United States again. A previous refusal does not always mean you can never enter the United States, but you need to know why the refusal took place and whether there is anything that can be done to be corrected. And you need to know that U.S. Immigration, they keep records, so they know everything that has happened in your past. Point number 7, what Canadians should bring to the U.S. border. If you are worried about refused entry in terms of to the United States, you need to prepare. Depending on the purpose of travel, helpful documents may include the following: a valid Canadian passport, return ticket or travel itinerary, hotel bookings or an address where you will stay during your temporary visit, proof of employment or business in Canada, proof of family, property, or other ties to Canada that will help you when you want to show you will be returning to Canada, conference registration details, a meeting agenda if you're meeting with clients or business development opportunities, invitation letters, employer letter, proof that your income and main work will remain outside the United States, an approved work petition or support letter if applicable, court records if there is criminal history for all the relevant cities, state, and federal FBI, and a waiver if one is required. The goal is not to overwhelm the officer with unnecessary documents. The goal is to be prepared if questions come up. Clear documents help support clear answers. Common mistakes Canadians make at the port of entry. The most common mistakes include the following: assuming a Canadian passport guarantees entry, making sure that you have a valid passport, calling something a business trip when it may actually be work without a work permit, trying to enter without the right work authorization, not preparing documents for a TN or other work category, assuming a DUI or criminal issue does not matter, forgetting that cannabis remains a U.S. federal issue and is still illegal, giving vague or inconsistent answers, failing to disclose past refusals or immigration problems, assuming that because you entered before, you will always be allowed in again. The best time to deal with the refusal concern is before you travel, not when you are standing in front of a border officer. So in closing, the U.S. remains one of the most common destinations for Canadians traveling for business, tourism, family, investment, and work. But entry is not automatic. If you have any concerns about criminal history, DUI, cannabis, previous refusals, business travel, or whether your activities require a work visa, it is important to get advice before you travel. At Ackah Business Immigration Law, we help individuals, families, executives, and professionals and companies prepare for cross-border travel and resolve refusal concerns. If borders are the problem, we're the solution. Thank you for joining me today on our LinkedIn Live. Take good care. Until next time, bye-bye.